Okay, hang on, people. This is day 8 of the trial. Defense is settling up. I don't know the witness they called. They didn't swear him in. They kind of did a few things this morning. This is starting. They just brought the jury in, so this is what you're seeing. The judge says thanks to the veterans. Very nice of him.
Okay, so you may proceed.
Call Dr. John Black to the witness stand.
Raise your right hand. Do you solemnly swear the testimony about the witness?
But he said John Black.
I do. Doctor, I'm going to hand you a series of documents and then ask you to testify and authenticate to them, please. Defense Exhibit 140.
That was tendered with my expert report.
And how long is that document?
43 pages, sir.
And does that include your life and professional experiences?
It includes the highlights of them, but yes, sir.
And what I want to get into is a little bit of your background as it applies to this case. Have you ever worked in a law enforcement capacity?
Yes, sir, I have.
How long?
Approximately 23 years.
Where?
Washington County, Oregon.
Is there a city around there that
It's the first county to sort of, if you're looking at it, between the coast and Portland.
Okay. And what were your duties in that department?
My duties range from a lot of stuff. I started as a patrol officer. It would be actually a deputy. From there, I was a corporal. I became a sergeant, again, in patrol or operations, what you commonly think about as patrolling. I was also a training sergeant. I then became a lieutenant, and there's 4 divisions in there: corrections, patrol, investigations, and support, sort of you think the way it operates. And then I was a lieutenant, and in some cases acting commander, which is the person that oversees all the operations within those.
So Kyle has been yawning a lot this morning, and I noticed that before the jury got in. He's yawning. I mean, really almost excessively. Could be stress, could be from lack of sleep, could be on meds from his little panic attack the other day. A lot of people were saying when he broke down on the stand, it was a panic attack versus just emotional. And looking back, I mean, I'm not a panic attack expert, but it did appear to be very uncontrolled, and it almost overwhelmed him, and he was just kind of stuck and couldn't get any words out. So I would characterize it as a panic attack, but I'm not a panic attack expert. Somebody's going to be here. It wasn't a panic. He was just crying. Whatever. All right. I'm just saying what some of the commenters said.
Individual divisions. Additionally, I oversaw professional standards, which is the unit that oversees if things are done right, if things can become better, to include internal affairs. And then I was also the person that oversaw and designed the use of force program within that agency.
At any time in the employment in law enforcement, did you have an opportunity to work with videographic evidence?
Oh, absolutely. As a deputy coming up, we would commonly use video type of evidence in our investigations. I mean, think about robberies or anything else. You have ATM video or similar type of things. When I oversaw such things in the jails are...
I'm assuming he's a use of force expert or some type of expert. I don't know if it's for digital. He kind of jumped in earlier this morning, and they were asking something about a program, and he goes, if they use this RRAP, whatever the program was, it creates a log, and now they're trying to find that log about how, and I still don't know, when you use a phone and you zoom in, is it just expanding the pixels that are there, or is it actually filling in to make the picture complete when you get too big? And I think that's the difference between regular zoom and digital zoom, because I know when I get to digital zoom on my other camera, it gets kind of fuzzy like a video a little bit if I go real high digital zoom, but when I go to regular zoom, it's clear. So if somebody's a digital expert in the comments, they can clear that up. I'll pin your comment. So write it so anybody that wants to figure out what they were talking about is, I'm sure there's AI program that can fill in. I mean, hell, like you probably go to Photoshop and it fills in color. But I don't know if just a typical pinch to zoom where you get on the camera and you move your fingers and it makes it bigger, if that actually changes the actual picture by filling in, or if it's the exact same picture, just closer. All right, here we go.
Commonly monitoring the cameras.
Maybe he'll clear that up.
Allegations of complaints, and for a period of time, as a jail operations lieutenant, I oversaw every allegation of a complaint. We would review evidence to include the video evidence. That would have been the time frame for that. As I oversaw the detective division, detectives, which oversaw sex crimes, homicides, car, passports, fraud.
All his experience.
Make sure that you have military. Because of that, I have several what they call military occupational specialties, or MOSs. One of the MOSs I have, I think last count was about 7 of them. One of them is specifically about intelligence, just like you think about intelligence to gather information. As part of being an intelligence qualified officer, or non-commissioned officer, is we would routinely look at surveillance video.
Nice phones in the courtroom. I can't believe the judge. Man, I've seen judge that has shit fits if your phone went off. Bring that phone up here. Bring that person and phone up here. Don't you know to turn off the phone? You can get it back after court. So you have to sit there all day and you wouldn't get it back till the end of the day. So you were screwed without your phone. This guy's pretty okay with phones, I guess.
We would use surveillance video to plan operations. We would covertly make sure video was happening, drone video. We use video in our how we operated. Body-worn cameras were with the military long before they were with police. And we would have to make sense of this video. Or when it came in from another thing, you have intelligence units. There was an entire portion of that unit designed to focus on what's called IMINT, or imagery intelligence, IMINT, non-court report. And then so because of that, we routinely both used it, operated with it, similar type of things.
And in the intelligence capacity, did you analyze, enhance, and do things to video?
When required.
Okay. When it was
When required.
And in the course of your profession, let me back up a second. I apologize. What was the highest rank you achieved in the military?
I retired from the military after 30 years with the rank of Sergeant Major, which, to put it lateral to other services, is an E9, or enlisted rank 9, which is, you got a command Sergeant Major, which I did as a, we'll call it a temporary duties, but I remained primarily an Operations Sergeant Major, which is the highest non-commissioned rank in the military.
Now, in this case, I engaged you for several tasks, but one of those was video analysis, correct?
Video analysis in support of understanding the event, yes.
And are you certified in the operation of any video programs that you used in this case?
Yes, I use a video program known as Input Ace.
I don't know how you get certified on a program. I want to hear this. Maybe he went through some training specifically and got certified, but I mean, am I certified on a Paint program or my email program? How do you get certified for a program? This will be interesting.
Version 2.6.3. Input Ace is a program specifically designed to allow people without a lot of high-level skill, like high computer forensics or anything else, to examine video in such a way that when you examine it, you're not doing things to it, like altering it or anything else, that when you're looking at it, you can have some trust in what you do with it, that you're looking at the best that it can be with what it can provide. And within Input Ace, I'm certified at what they call both the operator level, and I'm also certified at the examiner level.
And what's the difference between an operator level and an examiner level?
So an operator level would, let's say, import videos, allow them to basically transfer with codecs or anything else. You could play them, maybe cut a couple pieces out, do these type of things. At an examiner level, you're actually doing, we'll call it manipulation. In other words, you're scaling it, you're looking at things, and so you have to have an understanding about how that happens. So, for example, there's certain ways, and I think you heard earlier in the testimony of Senior Examiner Armstrong, he used the word interpolation. So with interpolation, there's certain ways things get interpolated. Not the word, but it will work for now. And so the thing is, if I don't understand those things, I can't have trust within what I'm working with to better understand the totality of the event and what I'm looking at.
Now, when you look at videographic evidence, is frames per second something that's important?
It's one of the things, yes, sir.
Tell the jury what frames per second means.
Yeah, I mean, it's frames per second. So when you look down on your phone and it's recording a video or something else like that, you might see something that's 30 FPS, the shorthand for frames per second. What that's telling you is, imagine if you were to take 30 still shots and just keep taking them at approximately 0.033 seconds, 30 frames per second, just take 1 second divided by 30. It would take 30 of those pictures in a continuous stream to make the 1 second that you're looking at, 30 frames per second. 60 frames per second. 60 frames just means that rather than having 30 still shots, you got 60 still shots. It's still 1 second, still the same resolution, potentially, depending if you haven't changed anything else. You're just getting more just micro snapshots with each point in time.
Do all videos run at the same frame per second amount?
Oh, no, absolutely not. And for example, in the examiner certifications, one of the things you're looking for, just to get a feel, is you look at things like frames per second and resolution and the codecs that it's used.
You see the difference in this guy's testimony compared to the other? He's explaining things, and I can tell he's law enforcement. He's explaining things so the jury can figure it out. He's not just saying, well, you extrapolated and, like the DA does. The DA acts like he's an expert in everything, and he just confuses shit. Everything he does, he breaks it down so somebody that's not a subject matter expert in what he's talking about, he kind of gives them a general idea of what it means so they can kind of keep up with him. I mean, it's easy to get up there and talk over somebody and use fancy terms and words and impress them, but it doesn't help who's paying you, his client, and help educate the jury. So he's doing a good job at explaining so far.
and these types of things. For example, 30 frames per second is common, but also 24 frames per second is common for high definition video because it's a more universal type of thing. Or I want to say 23.95 something or 6 something is used for what they call NTSC, N November Tango Sierra Charlie, which is more of a European format like PAL. So the fact is, the short answer is the frame rates will vary depending on who's using what kind of camera equipment or what they're trying to do.
Now, resolution is also a part of the analysis?
Resolution is part of understanding the video, yes.
And what is, how do you define resolution?
Yeah, it's defined a couple different ways, but it really is talking about the same thing, and I think you heard it. Is it all right to refer to my notes? Yeah, ma'am. Refer to my notes? Sure.
The reason why you asked that is because a lot of times, remember I talked about where a metal examiner was looking down and getting dates? You're supposed to get a permission so they know you're referring to your notes. You're not supposed to do it secretly and act like you know everything and you're referring. Kind of like the DA does. He's reading down and he's acting like he's smart and he's basically reading things. They don't want witnesses tricking the juror like I'm really smart and they're actually looking at crib notes. It's like passing a test when you got the answers on your hand. So that's why they want to make sure it's clear. Yes, you're referring to your notes. We understand that.
The idea of what they were looking at when they're talking about one of the exhibits is 1920 by 844. So the question is, what does that mean? It means 1920 pixels across and 844 pixels high. So if you were to take each...
I didn't know that. That's pretty cool. I'm glad he said that because I'm always wondering when I'm adjusting my frame around the different videos, it gives me all those numbers, and I just know when it gets 1080 by something, I think that's high def, whatever the hell that is.
One of those things, basically a pixel is the smallest element within that picture of a single color. Just like a Lego block, that's all it is. So 1920 across, 844 high. Well, if I spread that out, and I think you guys, I apologize, but to the jury, imagine taking your phone and you spread it out, you get those sort of sharp edges where it looks like you get a bunch of squares together. You're looking at the edges of where the pixels are. When those things begin to get smoothed out, a lot of times what that is, and the software does amazing stuff, is that software smoothing it out or what's called interpolating it, enhancing it, clarifying it. There's other verbs given to it. But so resolution is actually very critical.
Now, when one tries to look at different videos, but syncing them up, what role does sound play?
Yeah, so one of the things that's kind of unique with when you have it like an MP4 file, a very common type of file, in a video format, there's a soundtrack to it. Well, when I try to store video, most programs, we want to sort of compress it up because it takes a lot of space. So what a lot of programs do is they'll take a look at it and say, hey, you know what, those 30 frames per second, 3 or 4 of them are just really exactly the same. So what I'm going to do is I'm going to get rid of those frames. It's just going to save me some space when I store it, right? But the audio track, which is completely separate, is not compressed. It's true against time. So what I do, and to understand and do the analysis, is I try to get as many different things, an audio track, take a look at the reports on what people perceive, take a look at the different videos, because remember, videos come from different perspectives. Sometimes we have them dead on, another person was to the left, and then what you do is you sort of put this all together to index it so you can get the best possible approximation of things like time and these type of things.
And is sound used to help sync up the video?
Yes, sir.
And when you use sound, do you use a computer program to analyze that?
I do.
What is that?
It's actually WaveMaster Pro by NCH.
Okay. And when sound is analyzed, it puts together what would commonly be like a picture graph that's, referred to as a waveform.
Yes.
And a waveform then allows you to see where the sound is for an event that's in the video, correct?
Well, it allows me to, so a waveform, if you've ever seen them, is those things that sort of have the big spikes in them and this type of stuff. A gunshot, for example. A gunshot has a loud percussive noise. I listen to the thing as it's playing, I see a big spike within the waveform. I can now mark that spike and say, that's the beginning of the gunshot. I listen some more, I watch the waveform shift, there's another spike. So what it allows me to do is it allows me to see a visual representation of sound, and now I don't have to be sort of hitting the space bar or using a stopwatch to hope I'm at or around the sound. I can actually mark that sound within it. It's the same if I look at it for 2 minutes or 20 minutes, the sound still occurs in the same place.
And you're using the frames per second, which is known, to determine the distance between shot 1 and shot 2, so to speak.
Actually, what I'm doing is within the sound software, I know that the time...
Now, right now, the prosecution could object because it's not responsive. He asked him as a statement, isn't that what you're doing? And now he's correcting and is starting to explain something. Technically, the DA could go, Your Honor, that's not responsive. Have him rephrase. Explain to me how you did it. And then he could say what he's doing. That's kind of legal jargon and courtroom, antics. And if you got two DAs and or defense attorneys that hate each other, they'll object and make you do it exactly the right way to be a pain in your ass the whole trial, and it's really irritating. These two attorneys have been kind of letting things pass pretty easy. And it's not real critical all the time, but when Kyle was on the stand and his defense team let the DA do all this bullshit of rapid fire questioning, making statement, editorializing, rephrasing, misrepresenting evidence, when he was allowing the DA to do all that shit, that was inappropriate and he should have objected. Should this be objected to? No, because then it'll look like you're just kind of messing with him and it might piss off the jury. So that's why I didn't object, but technically he could have.
Between, let's just say, and let's use gunshots. Shot 1 and shot 2, whatever that might be, but 2 shots. We'll call them shot 1 and shot 2. As they play in front of me, I can mark them. I see a finite time measurement. I can now, with an index point back in the video, I can go back to the video and say, oh look, there's the same place that sound is occurring in the video frames. Well, now since I have a known time from the sound, I can then begin to take that known time and back it up to the other shot. Now, a quick point of clarification. Sound does not travel absolutely perfect. Shorthand is basically, for the time in this place, the distance of 1,100 feet, which is about where this event was occurring, it would take sound about a second to travel. So if you were standing in the middle of all this, it might be half a second this way or half a second that way. So
how much time does it take for sound to get to the moon and back? Never mind. That's another topic.
You make allowances for that, but you have to understand that sound isn't an absolute determiner. That's why you have to take all this in total when you're thinking about it. But that's part of the way that you index.
Now, in the course of your engagement in this case, you prepared a report which was labeled a supplemental report, Exhibit 141, correct?
That is correct.
And then, because there was new videographic evidence found recently, you added to a supplemental, and that is Exhibit 141, correct?
Well, 141 is the supplemental, as at least what I have in my hand.
The preliminary is 139, and the sup is 141.
That is correct.
Okay. If I misspoke, I apologize. And you also did a timesheet.
That's really good when your expert witness corrects the attorneys. You may look at it as the attorney's a dumbass, but it gives the witness credibility because he's paying attention. So the jury right now is saying, man, I'd rather listen to him than the attorney, which is what you want. He's your expert. So I'm not saying he did this on purpose, but sometimes something like that can help credibility of your witness.
Which is Exhibit 142, correct?
Also correct.
Now, what I was looking from you was for the total time of events that happened on August 25th of 2020, beginning with what happened at Car Source 1, correct?
Part of the timings, that's my understanding, yes.
And I gave you what would be a known time where Kyle is on video stating friendly, friendly, friendly. And you synced that amongst other videos, correct?
You gave me a known location to look at. The time is estimated. And then what I did is using that as a start point, I actually found other places to sync, and I worked backwards to that time.
And when you synced up all the different, not all the different videos, but the videos that you used in this case, you were able to get them to sync to what level?
In the first point, the sync points that I primarily use as points of reference. So just think about something that can be seen in a bunch of different things. So the sync points that I used was the high arc of the bag being thrown. You can see the different shadows and everything else. So from a video point, I was able to find that in a lot of different places, and I use that as a sync point. The other thing from an audio standpoint is the gunshots. Now the gunshots can move depending on how far the person is away that's recording that sound. And in these cases, it could be 150 feet is about 1/10 of a second or a little bit more. So between the different things, I would say I have confidence in the different timings here, plus or minus 1/10 of a second.
Now, and then I asked you to break down basically into several groups, but event number 1 starting with friendly, friendly, correct?
Yes, sir.
What I would refer to as the transition from event 1 to event 2, correct?
Yes, sir.
And then event number 2 from beginning to end.
With the beginning being from the first strike with what's been shown as a person with a rock-like object.
Okay. And then the end of event 2 would be defined as what?
The 4th shot by Kyle Rittenhouse.
And from the end of event 2 going on to end being what?
Are you asking the point in time or the actual measurement?
The actual act that ended your calculation.
So from the 4th shot by Kyle Rittenhouse in event 2 until the point where he's seen in the video raising his hands, and I refer to that simply as surrender to the police.
And you used in your calculations of time and video.
Surrender pose?
Rittenhouse in event 2 until the point where he's seen in the video raising his hands, and I refer to that simply as surrender to the police.
And you
A surrender what? I'm missing that.
Where he's seen in the video raising his hands, and I refer to that simply as surrender to the police.
And
Surrender
you
to
used,
police.
in your calculations of time and video, you used 6 different videos?
I looked at all of them. I narrowed it down to the ones that are most relevant so I could keep the timings consistent.
So what you're saying is there's 100, and I'm throwing out a number, but over 100 different videos. Those are the 7 that you used to calculate these times and values.
Those are the primary ones, and then I validated them with the other ones.
Okay. Now, let's get started with that. The start of event number 1, do you have that available?
Yes, as in, do you want me to show it by video?
Yes.
Okay. So at this point, and understanding what this point is, this is from, if you can see on your screen, the parent file. This would be the point where friendly, friendly, friendly is heard within the soundtrack, and obviously we can play that as well.
Please.
Your Honor, I'm going to check this is beyond the scope of the court's order.
Beyond the scope of the court's order. So, when the defense is objecting, this can be a good or bad thing, because this can be, the jury can see that as, we wanted to see this. Why don't you want us to see this? So, you need to be careful when you're objecting, because the jury may get the impression that you're trying to hide. And again, I'm sure this is the weasel. I'm going to refer to D.A. Binger as the weasel from now on. This is exactly what he is doing right now. He's trying to hide. He doesn't want this out because it hurts his case. But he's going to object saying, oh, Your Honor, it was a past your order. So let's see what the judge rules.
This is all timing.
One of those 5-minute breaks in the library.
Oh, he's going to rule out of the court, out of the jury.
3A1. That subsection reads,
This is a report, counsel.
page 19, subsection 3A1. This pertains to the shots at Joseph Rosenbaum. That subsection reads, the 4 shots occur in approximately 1 second, with the times in hundredths of a second of 0.26, 0.25, and 0.23 respectively between shots 1, 2, 3, and 4. The court has also ruled that the witness can testify as to the information contained on page 22 of his report in paragraph 4A and 4A1. That pertains to the timing of the shots in what counsel describes as the second event, where the defendant shoots at the unidentified individual, Mr. Huber and Mr. Grosskreutz. And there's some timing information there. I won't read it right now because it's a little bit longer. But the court's order is very specific, that those are the items he can testify about with regard to timing. There's another section of his report he can testify about that has to do with sense-making, but right now he's being asked about timing. And we have a document, which I guess is exhibit number 142, that was just presented to us this morning. It appears to have 31 different time entries on it.
Oh, I lost
all
audio.
of them, except for like 4 or 5 of them, are beyond the scope of the court's order. This document contains characterizations of behavior that this witness is not allowed to testify about.
I haven't seen the document.
Okay, so for example, he indicates with observation number 7.
Go ahead, Mr. Binger.
Observation number 7 is characterized by this witness as JR elevation change hyphen lunge decision point. What I'm interpreting that is Joseph Rosenbaum's elevation change lunge decision point. This witness is not, by the court's order, allowed to testify as to what Mr. Rosenbaum was doing or his intent or anything like that. This was the subject of our motion hearing, and the court has excluded that. There's other characterizations too. For
Sounds
example,
like you might have a point.
Reference observation point number 15 and 16, referring to people striking the defendant. Number 19, striking the defendant. Number 22, striking the defendant. Number 25, the gun of Gage Grosskreutz pointed towards the defendant. These are all things that the preliminary report that this witness offered talked about, but now we have ruled, or we agreed in the court's order, that he's not going to be talking about those things. So the scope of this document, 142, is well beyond the court's order. What he's being asked right now, and when I objected, is beyond the court's order. What he is characterizing in this Exhibit 142 in terms of his interpretation of what various people in the case were doing or what their intent was or anything like that is beyond the scope of the court's order. So my understanding from the court's order was he'd be able to say gunshot 1, 2, 3, and 4 to Rosenbaum happened in this amount of time. And then the second set of gunshots happened in this amount of time. And that's it, as far as the timing.
That may be your understanding. Let's see what the judge's understanding is. I think the defense ought to be saying, Your Honor, this is to clarify for the jury. They've made this thing about time, and he shot 4 separate shots. This is critical for the jury to make a good decision and to have the facts. We're not making things up. We're simply showing the video and explaining it so the jury has all the facts. Hopefully they will come back with something like that and the judge will let him say it. Because I think this is good. If you were on a jury, wouldn't you want to know this? I mean, wouldn't you understand? Hey, man, the kid made a shot. Those shots were one fraction of a second. He fired all 4 shots in less than 1 second. And they're making it act like, yeah, he shot him in the chest, didn't he? You shot him out here. And when you shot him and he was falling, and you know how long it takes for somebody to fall when they're shot? A whole lot more than a fraction of a second between those 4 shots. So to me, it should be allowed, but the court always disallows a lot of shit because of sleazy DAs like AKA DA Binger, who we'll refer to from now on as the Weasel.
The court's order was very specific as to that. So when we're talking about friendly...
So this DA right here is kind of shoving back to the judge and pushing back. You got on my ass about your order and me not following it. And now I'm giving it back to you. You made an order and you want me to follow it, you better make him follow it. That's what this is in disguise.
Friendly, or throwing the bag or things like that, that's outside of that time frame.
I'm using demonstrative evidence to show how he reached these times. And it's all evidence that's already been testified to and admitted. Some of the evidence has been enhanced, just like the state enhanced the bag. Some of the other photos. He's a licensed, trained video specialist. He has the background, and we're showing the jury what he used to get these values. And that shows how he did it and the reliability of doing it. And I'm not worried about what Mr. Binger's talking about, the comments or anything like that. That's a way that he found the times. Your Honor, just time in relationship to video in this case is so important. Yesterday afternoon, Mr. Binger spent much time cross-examining my client regarding those approximately 30 frames from the Bitchute on the scene. And that was approximately a tenth of a second. And he spread it out, and what we're trying to do is show through video the true events of that night. And I believe it is with the court's order, because basically what we're looking at is an event, and the state can quibble with my time of when I started the event. They might say it's back 5-10 seconds before or whatever, but the total time of the event...
Hang on, there's some freaking big old van parked down at my driveway, and I don't know what they're doing, so I gotta go check that. I'll be back. Okay, so, I'm back. I didn't see him drop anything off, but I just got a notification from my, my girl, and she said that a package was delivered, so evidently was. And I went ahead and grabbed some lunch. So I'm doing this. It's what? 2:15 here in Texas. Here we go.
Until he surrenders at the police car, but can quibble with my time of when I started the event. They might say it's back 5-10 seconds before or whatever, but the total time of the event from friendly until he surrenders at the police car, 2 minutes and 55 seconds. The jury should know that. The events of each of the sub-events, the total time. The jury should know that. What happened between the 2 events? The jury should know that. They've been shown videos already of that.
Well,
If I may respond briefly.
yes, sir.
First of all, what counsel's just mentioned in terms of the overall timing is something he's free to play video and argue. The question is what this expert witness can testify to. The court has ordered specifically what he can and cannot testify to. Your order is one of limitation. It specifies the limits of what he can testify to. It's a fundamental notice issue, Your Honor. In his preliminary report, he didn't have information regarding the timing from friendly. That was a report from 3 months ago. We were not put on notice that there would be this testimony through this witness as to the timing of from the very beginning of all this to the very end. This Exhibit 142 is the first document we've received, and it was received today.
It was provided yesterday.
You notice defense, he's going to tell him don't interrupt me, but you notice defense is all upset when they don't get something right away, but yet they had the other video they dropped on them yesterday and never discovered it.
Don't interrupt. Don't interrupt.
It is the first document we've received from the defense pertaining to this witness with regard to the timing of the entire evening. It is beyond the court's order. We have not received proper notice as to this subject. I have no problem having this witness testify to observations 8, 9, 10, and 11. That is the exact scope of the court's order. Shot 1, shot 2, shot 3, shot 4. I have no problem with him testifying.
He might win if the court order is that specific.
As to items, observations 20, 21, 23, and 26. Those are the 4 shots in the second incident with Rose-Croix Fever and the unknown assailant. That's exactly what this court limited him to. Those 8 observations on the sheet of paper. Everything else on this exhibit, which we just received, is beyond the scope of the court's order. We've not been provided notice of it. It wasn't in his original preliminary report. It is being sprung on us in the middle of trial. The court has ordered on this. We had a hearing on this. The court gave the defense opportunity to put us on notice of these things. We talked about these limitations. There was an agreement among the parties as to these limitations, which led to your order,
gotta
Your
order
Honor.
me a
And
weed.
now the defense is going around that order. And I object to that.
Your Honor, I asked the court to think back to what's happened procedurally in this case. That FBI video didn't come around until about 2 weeks before trial. The drone video didn't come back until during trial. And most of this work has been done over the last 2 days to catch up to those exhibits. I provided this exhibit yesterday afternoon when it was first provided. The only change to it is and was a typo, which actually inures to the state's benefit by adding approximately 9 seconds.
I quibble with counsel. The FBI video was made available to counsel over 3 months ago.
I don't want to. You know what? I don't want to get into it. I don't want to get into it. It's been argued about before, and then we laid it aside. And at this point, I don't think I want to get into that because it isn't going to be.
This is a very common trick by the prosecution. They discover a whole bunch of shit. They get you to sign for it instead of check it off. And then later, when you don't have it, it's like, I never got that. Oh, we gave it to you. You must have lost it. Very common DA government prosecution trick to screw the defense over. It's not an accident.
Helpful to resolution of the issues that were after in the case. You know, I'm looking for the order. What was the date of that order?
I think it was November 2nd, Your Honor, but I'll pull it up here.
I believe that order was drafted by Mr. Binger.
It was.
And
I
I-
submitted it to all parties. There was no objection to it. It was signed with no objection.
Okay.
And then the video
Yeah.
came up after that.
Okay. I am. Here it is.
When you let your enemy draft an order for the court and you don't object, what do you expect? It's going to be in his favor.
All right. Now I say the order without objection, without really giving it a lot of scrutiny. Yet, as you know, we try a lot of cases in here, and because it came in without objection, I signed it, thinking that it covered what I had envisioned at the time of the hearing. I will tell you what I had in mind when, and I haven't looked at if there is even a transcript in existence. I don't think so, but it certainly was my impression that we were talking about video of the entire episode, and not that it certainly in my mind was not limited to
I love it.
specific numbers on this observation point list that you're talking about. I'm a little bit challenged when you say, is there something that I'm saying that draws the face that you're making? Go ahead, say what you
I
want
have to say, Your Honor.
Oh, did you hear that? Is there something I'm saying in regards to the face? Because this guy is always making his sarcastic smart-ass shit. And the judge just called him out on it. That is fucking... You want to piss off a judge? Make faces while he's talking.
Observation point list that you're talking about. I'm a little bit challenged when you say, is there something that I'm saying that draws the face that you're making? Go ahead, say what you want to say.
So the judge got it on the record. Is there something I'm saying that draw on the face? This shows contemptible behavior by the DA. It's on the record now. When somebody reads it, they're going to know that he's prompting a lot of this shit.
Say, Your Honor, yesterday I was the target of your ire for disregarding your orders. Today, the defense is disregarding your order. I submitted that draft of that order to the defense. They had an opportunity to review it. They had an opportunity to object to it. We do this all the time in the court system. We submit proposed orders to the defense, to the other side, and to the court for everyone to take a look at. If anyone had a change, an objection to that, if they wanted to expand it, there was plenty of opportunity to do so. There was no response whatsoever from the defense. They never came to this court and said, the proposed order is improper, here is our version of the order. They never came to the court and said the proposed order needs to be amended in some way. They never responded at all, even though they had it, and even though they had plenty of opportunity to do so. They have every incentive to make sure that the court's order with regard to their expert witness is accurate. They have every incentive to make sure that that court order gives them the opportunity to get in all of the evidence through this expert that they feel they need to get in.
You notice how when the government has something on their side, they think the law is crystal clear and there's no way you should do it. But every time the DA has misconstrued to like try to get that guy to intimidate the witness and called names and had objections sustained and mouthed off the court, all that, the rules and the orders don't matter to government. It only matters to everyone else.
Despite having that very powerful incentive, they did not object, they did not contact the court or me with any reaction to that order. You are the referee. The parties argue about things and you make a decision. We reached an agreement on this at the daughter here.
I don't think on this issue.
I proposed this compromise, right? I did, because there was some back and forth about the extent of the use of force issues and all that stuff. And I said, well, what about if we just agree, Dr. Black can talk about the timing of the shots and the sense making. And I then drafted this order. You gave the defense an opportunity to object. They didn't. You signed it. And my recollection, and again, I know you referenced the transcript, but in his preliminary report, Your Honor, all he talks about is the timing of the shots. In event 1, the 4 shots of Rosenbaum. In event 2, the shots of against the unknown assailant Lieber. So there's nothing further in his preliminary report about the extent of this entire time frame. This exhibit 140.
That's why it's called a preliminary report. It's not a complete report. If he was arguing the other way, then preliminary report would mean preliminary and not the entire thing. But because he's not, now all of a sudden the preliminary report is supposed to be the entire report.
42 goes well beyond his preliminary report from July 31st. It goes well beyond what we talked about in the Daubert hearing. It goes well beyond what we agreed to that day. And it goes well beyond this court's order.
If I understand correctly, what's being pursued by the state at this point is timing sequence for the time between the friendly and the surrender to the police, which he says is a total of 400 and some, or attempted surrender to the police, which he says is a total of 4 minutes and some seconds. All of which is, every second of which I think has been analyzed here in this courtroom. That was certainly my vision at the time we discussed all this, whether it was, each part was specifically discussed in his preliminary report or not. That was my vision of what we were going to be hearing. And I guess the questions I have is, what is the prejudice to the state? Are you suggesting that what he's about to testify to, or may testify to, is going to be different with respect to the new periods of time than it is with respect to the particular periods that you identified?
So the judge is setting up a good defense for his ruling because he knows the DA is going to be pissed. So he's trying to say, look, you're all upset that I'm going to allow this. We've already talked about it. Everybody's seen it. How is this going to hurt you? You know how it's going to hurt you? Because it makes the jury more educated and able to make a better response. That's how it hurts the defense.
In the order that you drafted? Or, that's number one, as to whether there's prejudice to the state. Secondly, whether you think that there is some incongruity between the periods of time that might be more fully covered by the examination of the entire time period. Because those are the principal issues. We're here, and you've practiced here. You were assigned here for quite a long time, some years ago. And I think that most people would say that I'm pretty open to, I want to have the whole thing presented to whomever is finding the facts, whether it's me or whether it's the jury. I want to know as much as possible rather than try to isolate particular things and say, well, that isn't. I told the story the other day about the judge from Madison who was tormented whether to grant a motion to dismiss a burglary case on failure of proof of venue, not just proof of venue, whether that municipality was in Dane County or not. And I think, really, are you really worried about this? I don't operate that way. Now, I'm not criticizing you for bringing up this issue. I think it's legitimate. But it's not something that sways my judgment in the case. And unless you can tell me that you have reason to believe that the doctor is going to testify differently about some of these other time periods within that less than 5 minute period, or that you are somehow prejudiced by the late arrival of the report, and I don't want to say late, although, okay, that's fair, then I'm going to allow the testimony to begin.
If I may respond here.
Please.
Yesterday, as I said, I was under the court's ire.
I don't want to talk about.
Well,
why don't
I
we
think it's a fundamental fairness issue, Your Honor.
All right, say what you want to say.
If I'm being held to obey the court's orders, I'm asking that the defense be held to that too. This is something we litigated.
He's getting on the record that he thinks it's not being fair and the judge is holding him to a higher standard than the defense. He's not trying to explain anything. He's getting it on the record to slam the judge. And the judge knows it. He ain't stupid.
At a Daubert hearing, we spent time on this.
I am going to interrupt you, and then I'm going to let you talk again. But I was talking yesterday about the Constitution of the United States and how the Supreme Court has interpreted it for 50 years. That's not what we're talking about here today.
So, this is a notice issue to the state. We have not been provided proper notice of this, and clearly if the shoe were on the other foot and we tried something like this, there would be quite a kerfluffle about that. That's one point. This is, as I said earlier, it's beyond even his preliminary report. Like he's just adding new things at the last minute like this. And this is not prompted by new drone footage or anything like that. There's no mention of drone footage in this report. So to fall behind the excuse of, well, other new evidence has come forward, doesn't change the fact that this is an expert. There are notice requirements for experts. There has been no notice of this issue. We've already litigated this, and now the defense is trying to expand it in direct violation of the court's order. One moment, Your Honor. I also wanted to point out that I think it's Exhibit 141 is a supplemental report that apparently Mr. Black prepared on October 24th, according to the date. We just got it yesterday. So again, another example of late notice here. I understand that the court wants to hear, or wants the jury to hear, the timing from the beginning of whenever we start to the end, whenever we draw that line. I understand that. There are other ways for us to do that, of course. We can take other videos. They all have timestamps on them. This expert is not needed for that. I don't think...
Okay, so why, if you're not a court person, why would it matter to the DA if this person gave the timeline or we just tell the jury and play the video? I mean, that sounds like, yeah, why would it matter? It matters. This guy he knows he's a good witness. He's testifying like he knows what he's talking about, and it's going to come from somebody other than just the DA saying, we accept judicial notice that the time period from here to here is so-and-so, and we've accepted that. And the time period from here to here is so-and-so, we accepted that. That doesn't let the expert say, this is a fraction of a second from here to here, and the shots were here. There's a big difference between it took him 5 minutes to get to the police, and when he was being attacked by 4 different people and shot and defended himself, it was less than 4 seconds. There's a big difference between that.
We're going to need that time frame down to the hundredths of a second. I think even tenths of a second, even 1 second is probably close enough for the jury to understand that this is not something that took days or hours. It was a matter of minutes. So I think they can already get that point without this expert's testimony.
They may be able to get it, but how does it prejudice you? How does it hurt you if they get it in 100 seconds or in, 1 second? How does that hurt you? Show me how you're harmed. He doesn't want to say he's harmed because he knows he doesn't have a legitimate reason.
One specific item of prejudice that I do want to bring to the court's attention is in Exhibit 142. As I pointed out earlier, there are characterizations here.
Well, I agree with you there. Doctors, I assume he's using it for to pinpoint particular events, and I agree with you. He's not going to be permitted to do that.
Okay, so I want to be, I just want to make sure we're all on the same page and that I'm understanding things clearly from the court. There are, for example, observation number 7 on 142 has a characterization of Mr. Rosenbaum's behavior. That will not be allowed?
He's going to have to find some way to express that that is not conclusory.
Change in elevation?
I'm going to try to let you do it in a prudent way, and if there's an objection, I'll deal with it.
Okay.
But yeah, I do think his objection is well stated, that there's some conclusory language in there which is to be
I can
avoided.
refer to, they're queued up. I can refer to, if he objects to that, I can just refer to it as 7.
That would seem to be unobjectionable.
I think if these are things where we're just going to show the jury that item, that moment in time, they can see it on the screen, then we don't need a witness to tell us what we're seeing. That
Well,
makes everything
I'm
easier.
not, I can't anticipate what he might ask or what your objection might be, so I'm not going to try to.
I would also continue by objecting to observations 15.
Go slow.
15.
As you mean to the description of the event that he gives?
Yes.
Yeah, I think any of his descriptions are going to have to be non-conclusory on his part.
That's fine.
Okay, perhaps just to point to the particular moment in time and say this is at.
If I was the defense, I would say, we understand you're going to be saying some things, but we understand you're not making a conclusion. You're only using this term for reference. And I think he complies with the judge's order. So he can still get the description in because the description, I think, is important. It connects it. It ties it together. So, but he doesn't want that. The DA doesn't want that because it hurts his case.
Such and such an hour, I don't know.
Can I list the ones that I want to raise for so we're
No, because you can object when it happens. Because maybe see, if I rule on everything now, then I may be talking about things that may never become an issue. And I'd rather, the jury's in the library now, and I'd rather get them out here.
Okay. One final thing, Your Honor. If there is any data or reports that are generated by the software that Dr. Black is using when he prepares all this, I would like that. We received a similar request from the defense this morning for Mr. Armstrong's things.
Imagine this is my weasel. Every time I show this and this guy's talking, imagine this is a weasel.
So I would like that information from the defense.
No problem. Do you have any? Just your
I
program?
can generate them. It's going to take a little bit of time, but they're all you can generate them all.
How much is a little bit of time?
Well, so Your Honor, the first thing I'd have to do in order to meet my understanding is I can go back in and relabel everything based on this.
You know what? I'm just trying to get the jury out here. How long are we talking about? Not why it's going to take as long as it will. How long will it take?
To relabel everything, I'm guessing about 5 to 10 minutes.
Oh,
in
okay.
order to do the reports, Your Honor, that'll take a little bit longer.
Okay. It doesn't seem like it's going to be a big problem. Before your cross, you should be able to at least get the basics. Okay? Anything else?
No.
Ask the jurist to come on, please. Okay, would you
So,
do that?
I need a. That's not just shown on the screen.
Oh, I found this. This will be my new weasel, even though it's a monkey.
No, you probably can't.
I think
Would you ask the jurors if they tell them it's going to be about 5 more minutes and they're welcome to go upstairs if they want or stay down here? And tell them I'm sorry I didn't turn on the music for them.
So I don't know what they're doing. What was the delay? I missed it. The judge sure does check his phone a lot. I wonder if he has judges or other people emailing him, hey, you kind of missed this. I wonder if he's got a trusted friend. Hey, man, when you're watching this, if you see me kind of stepping on my pee-pee or I can make a good point, hook me up and text me, which would be nice. All right, I'm bumping forward. Let me pause it because it looks like it's going to be a while. Okay, here we go.
How long was that 5-minute break? All right, we're going to be on our best behavior from here on in. Mr.
Dr. Black.
I want to go back. When the judge asked the jury, how long was that break? I want you to see how the weasel, where's my weasel? How the weasel DA kind of smiles at the jury and is communication and bonding like we're buddies. The defense is working, and he's over here. Watch his face. It's very quick on the corner of the screen here.
How long was that 5-minute break? All right, we're going to be on our best behavior from here on in.
Yeah, see that smirk? See that? Oh, yeah. So, see, I'm your friend, and this guy is too busy doing his job or busy right now. He doesn't care about you. Subliminal little messages. This is all a big game to convince the jury to vote your way regardless of truth, fact, or justice.
Mr.
Thank you. Dr. Black, just to back up, the time calculations that I asked you to perform of the events of August 25th of 2020 from what we would refer to as, I'm trying to find it, observation number 3, which has been labeled PSSP now. Oh,
It's just a screensaver of a certain type of content. I do not. No.
which has been labeled PSSP till observation 31, which is now going to be labeled STP. What is the total amount of time of this event?
2 minutes and 55 seconds, approximately. It's calculated out. There's a bunch of variables in there, but approximately 2 minutes and 55 seconds, slightly under 3 minutes.
Please show video PSSP.
It's at 100%, 1280 by 720, and if you wanted more knowledge about it, then 30 frames per second, et cetera, et cetera.
Okay.
But it's unchanged.
Please play the video.
Okay, this is just a still frame, sir, that you want.
Okay.
There. But I can play from here. Is that what you're asking?
Yes.
Okay. It's I'm gonna have to finish processing for a second.
Stop, please. Now, that is in this calculation of time, that would be the 0 frame. Is that a fair statement?
Yes, so what at this point here,
I'm a little confused at this point.
that would be approximately where what you're referring to as the 0 frame. That red mark would be the 0 frame.
Okay. Now, the next observation 4, which is JRPK, did you do anything to enhance this video?
No, but I'm gonna have to, with the numbering while we're gone, that bit, you're asking for an observation that's no longer sitting in this. I mean, and maybe I'm misunderstanding what you're asking for.
Well, in the Exhibit 142, observation 4, we've agreed to label it JRPK.
Right, but, okay. As part of what happened with what we had discussed, the observation 4 that's on here is no longer in the menu to the left. If I have to, I'd have to bring it back. I can get you there. if you
Is
want.
observation 5 available?
Yes, sir.
Okay. And observation 5, the event described has been labeled BBTB. Has anything been done to enhance this?
No, and this idea, as I'm bringing it up, in answer to your question, there's different places where observation 5 that you're referring to is being shown.
See, the prosecution won. Rick, why are you saying he won? The prosecution won. He made him relabel and change and disconnect, and now he looks disheveled and he doesn't look organized. He doesn't look like the guy he was prepared to play, and he had everything set up, and the DA has totally messed that up, And now the jury is like, man, these guys didn't have their, man, he don't have his shit. Because they have no idea that all this argument and changes went on. So he should say, look, I apologize to the jury for not having this, but because of the ruling, we had to relabel some things. And this is why I appear unorganized. I apologize to you guys, but I'm going to do it as quick as I can because I'm relabeling from the time you went to the break. And the defense may go, objection, Your Honor, whatever. He's got to make the jury know, look, this isn't me fucking around here being inappropriate. They changed the freaking rules on me, and now I got to rename and change and flip and make sure I don't violate the court's order.
In different videos. This is one of those.
Okay, please play this video. Stop. Going to observation 7, which has been now labeled JREC. Do you have that?
I do, sir.
Can you go back to the...
I will.
Anyone else confused what we're watching and why we're watching it? I have no clue.
You ready?
I am.
Why are you wasting my
Can you
time?
play that, please? Stop. Now, this screen is the start of the gunshots that have been attributed to Kyle Rittenhouse, correct?
For what's been referred to as event 1, that is correct.
Okay. And using your program regarding sound and video, you have determined how far apart shot 1 and shot 4 were, correct?
I have.
And that's by using the frames per second and the audio graph?
It's a combination between them both, but yes.
Okay. And if I label shot 1 as 0 time, when does shot 2 occur?
Approximately 3/4 of a second by the different timings, 0.739.
Wait, I want to get shot number 2
Oh,
first.
I'm sorry, my fault. The second shot, using shot 1 as a 0 point, would occur 0.263 seconds after shot 1.
Okay. And what is the time?
He didn't make it clear point. It sounded like 2.3 seconds. Make sure you get that point 2. I think he said point 2, didn't he?
Number 2
Oh, I'm
first.
sorry, my fault. The second shot, using shot 1 as a 0 point, would occur 0.263 seconds after.
0.263. I missed it, so if I missed it, the jury might have missed it. Maybe nobody else. Maybe I'm the only dummy here that missed it. Maybe all you guys got it. I think he needed to make that clear. 0.2, 1/5 of a second, or a little more than 1/5 of a second. Somehow describe it in layman terms so the jury gets how fast that was.
Shot 1.
Okay. And what is the time between shots? What is the second and third shot?
The time between the second and third shot would be 0.247.
And the time elapsed between the third and fourth shot?
The time between the third and fourth shot would be 0.229.
And the total of those 4 shots fired by Kyle Rittenhouse occur in what amount of time?
0.739, or again, approximately 3/4 of a second.
3/4 of a second, 4 shots. And if you listen to the prosecutor the other day, he made it sound like Kyle had like hours. Well, isn't it true after you fired the first shot, he was falling and you could have stopped and you chose to shoot him a second and then you chose to shoot him a third? He didn't choose in that.
Now, the shot, and you're looking at this videos, is not, those 4 shots are not the first shot, correct?
The first shot within the soundtrack around that time, those 4 shots are not the first shot that I hear within examining this video. That is correct.
And how many shots or shot were heard before those 4 shots?
Well, there's gunshots throughout the evening that I examined, but there's one clear shot that's heard prior to that.
And that occurred how many seconds before shot 0 or shot 1, which is the same shot?
So the shot, you referred to 2 shots as shot 1. So shot 0, the difference between what we're calling the first shot and then shot 0, is that correct?
Well, no, what I will refer to as the Zeminski shot. Counsel, we agree that the first shot was Mr. Zeminski. The Zeminski shot to Kyle, shot 0.
The time between the Zeminski shot, as you referred to it, and the shot attributed to Kyle Rittenhouse as his first shot would be approximately
1 second. I'm guessing.
About-
1.2?
about 2 3/4 seconds.
Oh, 2 3/4.
Again, I can look at the exact thing if you want. I just don't have the
That's
time
fine,
in front of
sir.
me.
Now, going down to screen 15, what we have labeled A1ST. Can you find that, please? Now, is this a still shot or a video?
This is a marked frame within the video stream.
Okay, could you back it up, say, 3 seconds?
That's approximately 2.5. Is that enough?
Go back just a little bit more. That's good.
Okay.
And would you play that? Stop.
See, I would have
Now-
asked, can you freeze it right where my client was?
That
hitting the head with a
observation,
rock?
according to Exhibit 142, took place 28 seconds after the beginning of Mr. Rittenhouse leaving Car Source 3.
You notice he didn't say after he shot Rottenbaum. The prosecution will say that's right after you killed Rottenbaum, but he didn't say that, which is good.
That is correct. There is an assumed time in there also.
Okay. Tell the jury about an assumed time.
So, when looking at these videos, I have no continuous video stream that takes me from event 1 into the front end of what we're calling event 2. There's a gap. So what I did was I took a look on the video, event 2 that we're looking at right now, that you've seen, it's referred to before as the BGO video, and I measured a distance at the pace that Kyle Rittenhouse was running, jogging, whatever we want to refer to it. I have a known distance, and I have a time that it took him to run that known distance. Because I also have another known distance where he came from in the prior stuff. What I did is I applied basic math, saying if it took him this long to run this, I'm going to just take that same time of running over here. And then what I did is I put that in as the gap to fill it in. It does not address if he may have stopped or anything else in between that. It simply addresses if it was a constant state of motion.
Now, and what was your general...
That was a good explanation. He's basically estimating if it took you this long to run this distance, and from this distance to here, we're going to assume this was this distance, then we're going to assume you're running the same speed, and it was approximate time. I mean, that makes it simple, but maybe the DA will make a big deal out of it.
I don't want to say general deviation, but what number did you come up with for that?
Basically, I used 9.05 or 9 seconds. So I allowed 9 seconds between the first part of it, and that's what's in the calculations. And again, those calculations are to add into the total time. Those calculations will not be, for example, time between shots or events that are on the same video stream, because those are known frames per second times a certain time equals a certain time.
So basically your calculation was that to run the distance of 150 feet, it took Kyle approximately 9 seconds.
Correct.
Now, what we've labeled the beginning of event number 2 was screen 15, which we just played, and that is depicting an individual on screen where Mr. Rittenhouse's hat is knocked off. Is that fair?
Yes, sir.
Okay. And the next event, which is screen 16, which we have labeled A2ST, could you go about 10 seconds before that and show that?
Okay, so screen 16 is here. You'll notice it says 11:50. I will try to get approximately 10 seconds earlier.
Stop.
Wonder if anybody tracked down the guy that assault with a deadly weapon, hit a guy in the back of the head with a rock, and run by him. I wonder if anybody tried to find him and maybe charge him for a crime. Deadly force. He used deadly force. DA didn't happen to bring that up, did he?
Did you do any slowing down of this observation?
Yes, I did.
Could you please show me that? What you just played for the jury was real time?
Yes, sir.
Okay, and there's a slow motion version?
Yes, much like what you saw Senior Examiner Armstrong this year, which is about to be played.
No. Stop that. Slow motion of screen 16.
See, the prosecutor or the defense ought to be saying when he's referring to things, can you go back right before my client was hit in the back of the head with a rock? Can you go back right before my client was kicked in the face? Can you go back right to the point where his gun was grabbed? That's how you get the jury to identify the same thing as you. He's trying to play with the DA's term and describe it so the jury knows exactly what you're looking at. Plus, you get to reaffirm what you've been saying the whole time. Your client's being attacked and bombarded with assault.
Is this the one you're referring to, sir?
Yes. Yes. Can you go back, please? We lost up.
Sure.
Are both of them on?
Take action.
I hope Kyle's mom picked out that tie, and he didn't pick it out himself.
Is everybody watching it on? Is everybody watching it on this one? Oh, there it goes. I don't know why it's not coming up on that one. Did you?
Is that the hit in the head? See, this is another reason that the prosecution didn't want this happening. Because now we're getting a jury to see how many times he was attacked over and over. See, the defense wanted to pull out the gun every second he could and say, you killed, isn't it true you killed, isn't it true you attempted to kill, isn't it true? He wanted to say that over and over again. Why? Because it programs a juror. Now, this is programming the assault, the assault, the assault. Good. Play the game. Well, this dude take his vitamins? He's got all this muscle here. Why are we in silent mode?
No. Stop.
Oh, that was a skateboard. I didn't even see that. Did y'all see a skateboard right here?
Stop. The next screen.
For those that don't know, when you hit somebody with a skateboard, that's called assault with a deadly weapon. No difference than hitting them with a bite, a pipe, a bat, any impact instrument, and you hit somebody in the head with it is assault with a deadly weapon because it could cause death or serious bodily injury. They didn't cover that terminology at all in this trial, and it really kind of amazes me.
Is 17, which we have labeled KRLB. Can you bring that up, sir?
All right, well, he's searching for that. This is 1 hour and 2 minutes. I'm going to start another one.